Okay, on page 126 of Criminal Procedure, within Chapter 3, Arrest, Search, and Seizure, Section 3, Probable Cause, Spinelli v. United States goes over the procedure of confidential informants. Justice Harlan delivered the opinion of the court in 1969. William Spinelli was convicted of traveling to St. Louis, Missouri from a nearby Illinois suburb with the intention of conducting gambling activities prescribed by Missouri law. At every appropriate stage in the proceedings in the lower courts, the constitutionality of the warrant, which authorized the FBI search that uncovered the evidence necessary for his conviction. Believing it desirable that the principles of Aguilar v. Texas in 1964 should be further explicated, we granted certiorari. In Aguilar, a search warrant had issued upon an affidavit of police officers who swore only that they had received reliable information from a credible person and do believe that narcotics were being illegally stored on the described premises. While recognizing that the constitutional requirement of probable cause can be satisfied by hearsay information, this court held the affidavit adequate for two reasons. First, the application failed to set forth any of the underlying circumstances necessary to enable the magistrate independently to judge of the validity of the informant's conclusion that the narcotics were where he said they were. Second, the affiant officers did not attempt to support their claim that their information was credible or his information reliable. The government is, however, quite right in saying that the FBI affidavit in the present case is more ample than that in Aguilar. Not only does it contain a report from synonymous informant, but it also contains a report of an independent FBI investigation, which is said to corroborate the informant's tip. We are then required to delineate the manner in which Aguilar's two-pronged test should be applied in these circumstances. In essence, the affidavit, ... meaning some text has been omitted, contain the following allegations. 1, 2, 3, and 4. 1, the FBI had kept track of Spinelli's movements on 5 days during the month of August 1965. On 4 of these occasions, Spinelli was seen crossing one of 2 bridges leading from Illinois to St. Louis, Missouri between 11 a.m. and 12:15 p.m. On 4 of the 5 days, Spinelli was also seen parking his car in a lot used by residents of an apartment house at 1108 Indian Circle Drive in St. Louis between 3:30 p.m. and 4:45 p.m. On one day, Spinelli was followed further and seen to enter a particular apartment in the building. An FBI check with the telephone company revealed that this apartment contained 2 telephones listed under the names Grace P. Hagen and carrying the numbers WY down 4-0029 and WY down 4-0136. The application stated that, and this is number 3, quote, William Spinelli is known to this affiant and to federal law enforcement agents and local law enforcement agents as a bookmaker and associate of bookmakers, a gambler, and an associate of gamblers, end quote. And fourth, finally, it was stated that the FBI has been informed by a confidential, reliable informant that William Spinelli is operating a confidential, reliable informant that is operating a handbook and accepting wagers and disseminating wagering information by means of the telephone, which have been assigned the numbers WY down 4-0029 and the same as before. There can be no question that the last item mentioned, detailing the informant's tip, has a fundamental place in this warrant application. Without it, probable cause could not be established. The first two items reflect only innocent seeming activity and data. Spinelli's travels to and from the apartment building and his entry into a particular apartment on one occasion could hardly be taken as bespeaking gambling activity, and there is surely nothing unusual about an apartment containing two separate telephones. Many a housekeeper indulges himself in this petty luxury. Finally, the allegation that Spinelli was known to the affiant and to other federal and law enforcement officers as a gambler and an associate of gamblers is but a bald and unilluminating assertion of suspicion that is entitled to no weight in appraising the magistrate's decision. And that's a quote from Nathanson v. United States, 1933. So much, indeed, the government does not deny. Rather, following the reasoning of the Court of Appeals, the government claims that the informant's tip gives a suspicious color to the FBI's reports detailing Spinelli's innocent-seeming conduct, and that, conversely, the FBI's surveillance corroborates the informant's tip, thereby entitling it to more weight. We believe, however, that the totality of the circumstances approach taken by the Court of Appeals paints with too broad a brush. Whereas here, the informer's tip is a necessary element in the filing of probable cause, as proper weight must be determined by a more precise analysis. The informer's report must first be measured against Aguilar's standards so that its probative value can be assessed. If the tip is found inadequate under Aguilar and other allegations which corroborate the information contained in the hearsay report should then be considered. At this stage as well, however, the standards enunciated in Aguilar must inform the magistrate's decision. He must ask, can it fairly be said that the tip, even when certain parts of it have been corroborated by independent sources, is as trustworthy as a tip which would pass Aguilar's test without independent corroboration? Applying these principles to the present test, we must first consider the weight to be given to the informer's tip when it is considered apart from the rest of the affidavit. It is clear that a commissioner could not credit it without abdicating his constitutional function. Though the affiant swore that his confidant was reliable, he offered the magistrate no reason in support of this conclusion. Perhaps even more important is the fact that Aguilar's other test has not been satisfied. The tip does not contain sufficient statement of an underlying circumstance from which the informer concluded that Spinelli was running a bookmaking operation. We are not told how the FBI's source received his information. It is not alleged that the informant personally observed Spinelli at work or that he ever placed a bet with him. Moreover, if the informant came by the information indirectly, he did not explain why his sources were reliable. In the absence of a statement detailing the manner in which the information was gathered, it is especially important that the tip describe the accused criminal's activity in sufficient detail so that the magistrate may know that he is relying on something more substantial than a casual rumor circulating in the underworld or an accusation merely on an individual's general reputation. The detail provided by the informant in Draper v. United States, 1959, provides a suitable benchmark. Good boy. Need more paper, honey? Provides a suitable benchmark. Here, while Hereford, the FBI's informer in that case, did not state the way in which he had obtained his information. He reported that Draper had gone to Chicago the day before by train and that he would return to Denver by train with 3 ounces of heroin on one of 2 specified mornings. However, Hereford went on to describe with minute particularity the clothes that Draper would be wearing upon his arrival at the Denver station. The magistrate, when confronted with such detail, could reasonably infer that the informant had gained his information in a reliable way. Such an inference cannot be made in the present case. Here, the only facts: Spinelli was using 2 specified telephones and that these phones were being used in gambling operations. This meager report could easily have been obtained from an offhand remark heard at a neighborhood bar. Nor do we believe that the patent doubts Aguilar raises as to the report's reliability are adequately resolved by a consideration of the allegations detailing the FBI's independent investigative efforts. At most, these allegations indicated that Spinelli could have used the telephone specified by the informant for some purpose. This cannot be by itself be said to support both the inference that the informer was generally trustworthy and that he had made his charge against Spinelli on the basis of information obtained in a reliable way. Once again, Draper provides a relevant comparison. Independent police work in that case corroborated much more than one small detail that had been provided by the informant. There, the police, upon agreeing the inbound Denver train on the second morning specified by informer Hereford, saw a man whose dress corresponded precisely to Hereford's detailed description. It was then apparent that the informant had not been fabricating his report out of whole cloth, since the report was of the sort which in common experience may be recognized as having been obtained in a reliable way. It was perfectly clear and that probable cause had been established. We conclude then that in the present case, the informant's tip, even when corroborated to the extent indicated, was not sufficient to provide the basis for a finding of probable cause. The judgment of the Court of Appeals is reversed. Justice White, concurring, adds the following. The tension between Draper and the Nathanson-Aguilar line of cases is evident from the course followed by the majority opinion, ... Since the informant's specific information about Spinelli using 2 phones with particular numbers have been verified, did not his allegation about gambling thereby become sufficiently more believable if the Draper principle is to be given any scope at all? I would think so, particularly since the information from the informant, which was verified, was not neutral or relevant information, but was material to proving the gambling allegation. 2 phones with different numbers in an apartment used away from home indicates a business use in an operation like bookmaking where multiple phones are needed. The Draper approach would reasonably justify the issuance of a warrant in this case, particularly since the police had some awareness of Spinelli's past activities. The majority, however, while seemingly embracing Draper, confines that case to its own facts. Pending full-scale reconsideration of that case on the one hand, or of the Nathanson-Aguilar cases on the other, I join the opinion of the court and the judgment of reversal, especially since a vote to affirm would produce an equally divided court. That's the end of Spinelli.